if you're in the area, we get to some of the, I hate to say bigger opinions because big is in the eye of the beholder when we're talking about the importance of a Supreme Court opinion. There are nerds in all areas of the law that find these decisions equally important. However, some of the more covered or hotly debated opinions come out towards the end of June. Today they're hearing a case about the FCC's E-rate program that subsidizes like underserved areas with the internet and schools. There's a challenge to the E-rate program that says that the FCC doesn't have the power to do that. It also has to do with the non-delegation doctrine. I will do a TikTok about it after we have oral argument today, once we get a sense maybe of where the justices are leaning. Jay Floyd, new location. No, I'm just where I usually, I will be in front of the court as we get closer to the end of the term. No, they're not doing every 10 minutes now. They kind of just put them all out there one at a time. Like I think last week we got the second opinion, 5 or so minutes after we got the first one. Is there anything monumental we're waiting for today? Yes. I think there are some major opinions that a lot of folks are waiting on today. We can talk through what's been outstanding. What time do they release opinions? In 13 minutes. You're welcome, St. Minds Collective. Let's take a look, shall we, at what decisions are outstanding. Thank you, Mr. Carter. And Loco Fiesta. Sorry that we consume you with dread. Hopefully we help you understand a little bit too. Thank you guys. Okay, so let's look at what cases are outstanding and what we might be getting today, what we might be in for. So the cases are bundled by a sitting where the Supreme Court sits for 2 weeks and they hear these oral arguments over the course of those 2 weeks. And so we call it the October sitting and the November sitting and the December sitting and the January sitting. So, and they kind of divide up the work for each sitting. So you can kind of get a sense, if one justice hasn't written from the October sitting, maybe who has that opinion. So let's look at the October sitting because we have most of the decisions already from October. I know we're still missing the Ghost Guns case, and that's whether Ghost Gun part kits, weapons part kits that have the pieces to make a weapon, to assemble a weapon, are regulated the same way that licensed firearm dealers have to go through the certain hoops they have to go through in order to sell regulated firearms as well. So it's whether these partially complete disassembled kits have to be regulated the same way as a firearm would be under the Gun Control Act of 1968. I think a lot of people are keeping an eye on that one. That's obviously it's not a Second Amendment challenge. It's an interpretation of the text of the statute, but it obviously has Second Amendment adjacent implications. I just got to notice that the SCOTUSblog live blog is up and going, so we should get a box count shortly. Let's see. Do we have a box count yet? Okay. All right. So that's missing. The Ghost Gun part kits case is missing from the October sitting. Was that the only one? No, we've got the medical marijuana case. That's an interesting one about the guy who was a truck driver who took a CBD product and he got drug tested, and turns out the CBD product had THC in it, and he lost his job even though he had called the company and asked to make sure there wasn't THC in it because he knew he got drug tested. And so the question in that case is whether he can sue under RICO for personal injuries as injuries related to business or property by reason of the defendant's acts, is like losing his job because they lied to him about the THC. Does that qualify under a suit that you can file under RICO, which is, meant to go after gangs, organized crime, stuff like that. the Racketeer Influenced and Corrupt Organizations Act. Those are the only two we're missing from October. So very possible we get one of those today. I think either one of those, lots of folks would be interested in. What's the most, how many boxes have I ever seen on a decision day? I think there's been a 4-box day that I've seen. But in the past few years, I have been outside the court with you guys and not inside the court with the boxes. Because they won't let me stream inside the court. Sadly. Maybe one day. Maybe one day we'll be allowed to have cameras in the courthouse, not even the courtroom, although maybe we'll have that one day too. Let's see if we have a box count yet. Oh, somebody's asking Amy how many. She says 3 boxes. She can't remember how many the most, but last June there were 3 boxes and they got 5 opinions. Yeah. All right, so we're waiting on 2 from the October sitting. Let's look at what we're waiting for from November. So in November, we've got a Medicare case. Whether the phrase entitled to benefits used twice in the same sentence in the Medicare Act means the same thing for Medicare Part A. It's the supplemental Social Security benefits. That one I think folks will be interested in. We also have an immigration case about whether a non-citizen's voluntary departure period ends on a weekend or public holiday. A motion to reopen filed the next business day is sufficient to avoid penalties for failure under the law. If you're a lawyer and you are responsible and you're in litigation and you are responsible for calculating deadlines for filing, that is a particular circle of hell sometimes, because you're looking at weekend days and holidays and making sure you're counting the next business day and what counts as the first day and what counts as the last day. And that can be a particularly challenging job. So that is an immigration case, but it's also about calculating what counts when that voluntary departure day ends on a weekend or a public holiday. And there has to be a Supreme Court case about that because calendar dates are very important in the law when you're required to meet certain deadlines. So I think we're only missing 2 from November as well. Just those 2. So 2 from October, 2 from November. Getting into December, of course, that's when we have Skirmetti, which we haven't gotten yet. I don't know that we'll get that this morning, but that's, of course, about Tennessee's bill that prohibits gender affirming care for trans minors. A lot of people waiting on that one. We are waiting on a bankruptcy case from early December. We're waiting on a criminal case about mail fraud, wire fraud. We're waiting on... Oh, yeah, there's an interesting case about, out of the Department of Transportation, Feliciano, about whether a federal civilian employee who's called or ordered to active duty under a provision of law during a national emergency is entitled to differential pay, even if the duty is not directly connected to the national emergency. And then we're waiting on a NEPA case, the National Environmental Policy Act, which requires agencies to do these like studies and evaluations on the environmental impacts before big projects are done. And then there's oftentimes with big projects, lots of challenges to the environmental impact assessment that's done, and that can tie up projects forever in the courts. That's December. So we're missing a few more from December. Let me see if we have a box count yet. This is your 5-minute bell. Do we have a box count? I don't think so. As Amy's pointing out in the chat, we're also waiting in the press room to see what happens with the Trump administration's request on the emergency docket for a stay of the district court's decision requiring the government to reinstate those thousands of probationary employees. The court hasn't called for a response, and the government had also asked for an administrative stay, which is a very temporary stay, to give the court time to consider its request. People are talking about a possible Alito retirement in the chat. I know some people were thinking perhaps he would retire at the end of this term to give Trump a chance to replace his seat. One box today. We have a one box count. Boxes are the number of physical boxes that are in the press office at the Supreme Court that can sometimes give us an indication of how many opinions. Where did I get that jacket? I got this jacket vintage. Like a vintage shop. I forget. I don't know what it is. Favorite daughter. Which I think is like usually a really nice jacket, but I got it like way discounted. There was not ever a resolution on the leak of the Dobbs case. Yes, hi. Meg River, eh? When will Thomas retire? That's a good question. I don't know. He may stay on for as long as he possibly can. All right, so one box today. Oh, hi, Meg. A lot of people are having anxiety, but also happy that we're live this morning. I understand. All right, this is your 2-minute warning. 2 minutes until the Supreme Court releases one or more decisions. You can follow along on the court's website if you want, or on SCOTUSblog's website if you want, but I will also talk you through it so you don't have to do any of that. I'll tell you who's writing the decision, what the holding is, and then we'll read a little bit of the decision. A reminder, opinions are released in reverse seniority of the justices, so if we get more than one, the most junior justice goes first. Of course, because it's a one-box day, it's possible we only get one decision today. We could get one medium-sized decision. It's possible. And then you can also turn on the live audio for the Supreme Court, who's going to hear arguments in the case, Consumers Research case today. That's going to happen shortly after 10 a.m., which is about the federal E-rate program from the FCC that subsidizes telephone and high-speed internet services for underserved areas. Challengers say that they don't have the authority to do that. And then there's a whole issue with the non-delegation doctrine, which is going to come up. Yes, I will probably go to YouTube if TikTok goes away. Although that's gone really quiet. I don't even know what's happening with that, but it seems like we're still alive and well on this app for now. All right, T-minus 1 minute till we all start hitting refresh simultaneously. Of course, if any of you guys are following and you get the opinion before me, let me know. And we'll find out together. 9 days left for TikTok. Where is that from? Is that one of the dates on the extensions or whatever? Okay, 10 a.m. Here we go. So recall we're waiting on 2 from October that are certainly possible that we get today. They've been pending the longest, although they may also have multiple opinions written. Sometimes the more contentious decisions often the more contentious decisions take longer to write because both there's a majority and a dissent, and that takes time. Sometimes the majority incorporates the dissent's points, and they have to show each other edits back and forth. Sometimes there are multiple writings, like concurrence or a separate writing in the dissent. And so those contentious decisions can take a while to write. That's also why it's important to justices to to try and build a coalition as much as they possibly can and find even the narrowest way to compromise in certain cases so that the court is speaking, with a stronger collective voice. If a 7-2 majority is a much clearer and stronger statement than a 5-4 with a fractured majority with multiple concurrences, right? In fact, if you go to law school, sometimes reading a 5-4 decision where there are multiple concurrences, even the majority's decision is unclear at times. All right, I'm hitting refresh. Hi, Kansas. Let me see if Amy has it in the chat. It's Justice Jackson, she says. United States v. Miller. Justice Jackson, which, as I said, doesn't tell us much about who's going next, but it's not the final decision of the day. Justice Jackson, joined by Roberts, Thomas, Alito, Sotomayor, Kagan, Kavanaugh, and Barrett. Gorsuch filed a dissenting opinion. And just last week, the pair were together in dissent by themselves. 106A's sovereign immunity waiver applies only to 544B claim itself and not to state law claims nested within the federal claim. So this is the bankruptcy case. Again, big is in the eye of the beholder. Lots of bankruptcy nerds. This will be important to them. This is not the final opinion. I'm just reading briefly from it, and I'll go to the next decision. The bankruptcy code empowers a bankruptcy trustee to set aside or avoid certain transfers of a debtor's assets in order to recover those assets for the benefit of the bankruptcy estate. This case concerns the trustee's avoidance power under 544B of the code. Under that provision, a trustee may avoid certain transfers that would be voidable under applicable law. That is, voidable outside the bankruptcy's proceedings. Trustees typically rely on state statutes to supply the applicable law when suing under 544B to avoid a debtor's transfer of assets. In this dispute, a trustee invoked Utah law as the basis for 544B suit seeking to claw back a debtor's federal tax payment. They want that money back. Ordinarily, the federal government's sovereign immunity would bar any suit against it under Utah law, but the bankruptcy code contains a sovereign immunity waiver, 106A, that abrogates the government's sovereign immunity with respect to 544, which is where they're bringing the suit. This case requires us to determine the immunity only with respect to the federal cause of action created by 544B, or whether it also abrogates sovereign immunity with respect to the underlying state law claims that supply the applicable law for the federal cause of action. We hold that 106A's sovereign immunity waiver applies only to 544B claims itself and not to any state law claims nested within the federal claim. So you can't kind of skirt around sovereign immunity with the state law claims that otherwise would be barred by general sovereign immunity. Section 106A is properly understood as a jurisdictional provision that empowers courts to hear 544B claims against the government to the extent such claims are otherwise available under state law. It does not alter the substantive meaning of 544B's applicable law clause to basically allow all these state law claims to come in that would otherwise be barred by sovereign immunity. That's the majority decision. Bankruptcy. I know there got to be some bankruptcy nerds on here. HTXer says lame, but bankruptcy is important, my friend. See, there we go. Pavo Reacts likes the clarifying rules. Good morning, Ohio. For those who have just joined, we have one opinion from the court. It's a bankruptcy decision from Justice Jackson. It was 8-1. With Gorsuch in dissent. We'll go back and look and see what the Gorsuch dissent is once we get the second opinion of the day. It's a one-box day, so I suspect we only have one more opinion. Sometimes we can read the tea leaves on who is next, like we could on Friday, because we got an opinion from Justice Thomas first, but because we got an opinion from Justice Jackson first, it could be anybody's day after this. How many are there today, Elite Gods? We're finding out right now. I think there are 2. That's my guess. But we'll see. Maybe it could be 2 in a dig. You never know. Or 1 in a dig. I don't know. I just try to consume as much caffeine in between opinions as possible. For those who are just joining, we have one opinion from the Supreme Court. It's a bankruptcy one that clarifies a provision in the bankruptcy code that allows It pierces sovereign immunity. It's a loophole. It's an exception. It's a waiver of sovereign immunity that allows people to sue the government. And the question was basically, how broad is that? Will that allow you to sweep in some state law claims? And the Supreme Court said, no, it's really narrow. It's just for this very specific provision in the bankruptcy code where we waive sovereign immunity as a government. And you can't nest, I think that was the verb they used, nest state law claims in that federal claim. But we're waiting on at least one more from the court. And I'm just going back to hit refresh. The bankruptcy decision was 8-1. Justice Jackson writing the majority. All of the justices joining her, except for Justice Gorsuch, who wrote a dissent. Hitting refresh. Oh, maybe the next one's a bigger one. How long was this one? 26 pages. The PDF is 26 pages. The opinion's shorter than that. Waiting. We're getting the gun case. Vanderstock. The ghost guns case. It's 7-2. Amy has it first. I'm waiting for it to load on the Supreme. Okay, here we go. It's now Bondi v. Vanderstock. It was Garland v. Vanderstock. This was the ghost gun parts case. Justice Gorsuch delivered the opinion of the court, joined by Roberts, Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson. Sotomayor, Kavanaugh, and Jackson each filed concurring opinions. Thomas and Alito filed dissenting opinions. The holding. The ATF's rule is not facially inconsistent with the Gun Control Act. So the ATF can regulate ghost gun parts kits in the way that it was similar to regulated firearms. Here's the beginning of the decision from Justice Gorsuch. It is the final one of the day. For decades, the Gun Control Act has regulated the sale of firearms. This case poses the question whether the Act's long-standing mandates also apply to those who make and sell a new product, weapon parts kits. By the way, this is out of the Fifth Circuit, I believe. And they're reversed. Okay, so shortly after the assassinations of Robert F. Kennedy and Dr. Martin Luther King Jr. stunned the nation, Congress adopted the Gun Control Act. Existing gun control measures, Congress found, allowed criminals to acquire largely untraceable guns too easily. Often, for example, criminals could evade state laws regulating in-person sales simply by purchasing guns through the mail. In response, Congress adopted a number of new mandates. As a result, many of those now engaged in importing, manufacturing, or dealing in firearms must obtain federal licenses, keep records of their sales, and conduct background checks before transferring firearms to private buyers. I am just going to flag. Existing gun control measures Congress found allowed criminals to get guns. Okay, in response, Congress adopted a number of new mandates. As a result, many of those now engaged in importing, manufacturing, or dealing firearms must obtain federal licenses, keep records of their sales, and conduct background checks before transferring firearms to private buyers. The act also requires importers and manufacturers to mark their firearms with serial numbers, aka not have ghost guns. These mandates serve at least two ends. The background check requirement seeks to keep guns out of the hands of criminals. The licensing, record keeping, and serialization requirements, meanwhile, aim to assist law enforcement authorities in investigating serious crimes by permitting them to determine where, by whom, or when a firearm was manufactured and to whom it was sold or otherwise transferred. Today, thousands of law enforcement agencies nationwide depend on the Act's tracing system to link firearms involved in crimes to their owners. The GCA's mandates apply to firearms, quote, firearms, and the law defines the key term broadly. Under the law, a firearm includes any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, and any firearm muffler or firearm silencer, or any destructive device. It's a pretty broad term. Thanks to this generous definition, the GCA has long been understood to reach everything from run-of-the-mill rifles to novelty umbrella guns. Recent years, however, have witnessed profound changes in how guns are made and sold. When Congress adopted the GCA in 1968, the milling equipment, materials needed, and designs were far too expensive for individuals to make firearms practically or reliably on their own. With the introduction of new technologies like 3D printing and reinforced polymers, that is no longer true. Today, companies are able to make and sell weapons part kits that individuals can assemble into functional firearms in their own homes. These kits vary widely, both in how complete they come and in how much work is required to finish them. At one end of the spectrum, a kit may lack essential parts and require substantial effort, specialized expertise, uncommon equipment, and a significant amount of time before anyone can fire a shot. At the other end, some kits contain all components necessary for a complete pistol and can be completed in perhaps half an hour using commonly available tools. Sales of these kits have grown exponentially. Home hobbyists enjoy assembling them, but criminals also find them attractive. That's largely due to how the kits are sold. Some manufacturers and dealers take the position that weapon part kits do not qualify as firearms under the Gun Control Act. As a result, they say they're free to sell their products without obtaining a federal license, conducting background checks, maintaining sales records, or marking components with serial numbers. The upshot? Police departments around the nation have confronted an explosion of crimes involving these ghost guns. In 2017, law enforcement agencies submitted 1,600 ghost guns to the federal government for tracing. By 2021, the number jumped to more than 19,000. That's an exponential increase from 1,600 to 19,000. Efforts to trace the ownership of these weapons the government represents have proven almost entirely futile. In 2022, the Bureau of Alcohol, Tobacco, Firearms, and Explosives adopted a new rule designed to combat proliferation of ghost guns. In doing so, the agency invoked authority Congress granted it to prescribe rules and regulations as are necessary to carry out the Gun Control Act. Two provisions in the agency's new rule are of special relevance here. The first addresses weapon parts kits directly. Recall 921A3 extends the gun control's mandates to firearms. Okay, I'm going to pause here. I'm continuing to read the Supreme Court's decision. I'm just going to give everyone an update. We have two decisions. That's it from the Supreme Court today. The first one clarifies a provision of the Bankruptcy Code about the government's waiver of sovereign immunity and narrows or clarifies the definition there that it doesn't allow you to also sweep in some state law claims that would otherwise be barred by sovereign immunity. The second decision is one of the major ones we've been waiting on from this term. It was argued early in the term in October about ghost gun parts kits. The Biden administration attempted to regulate ghost gun parts kits or weapon parts kits similar to federally licensed firearms. And that requires background checks, putting serial numbers or identifiers on them, and having a license in order to deal them. Challengers argued that they didn't have to do that. These aren't firearms under the Gun Control Act, but the Supreme Court said in a 7-2 decision, yes, parts kits are swept in the definition that allows the ATF to regulate these part kits in the same way that they would regulate, a firearm as we would imagine it. So that is a win for the government. It was the Biden administration that put forward the regulation. But at the end of the day, ghost gun part kits can be regulated as federally licensed firearms, including background checks, serial numbers, etc. Two decisions today. I will get to the dissent. I'm just reading briefly from the majority. I will go briefly to the dissent in the gun case. By the way, there's art in the decision, which there usually is not. You don't usually get full color images in the decision. There were also multiple concurrences, which could make interpretation of the majority somewhat complicated. All right, let's go to the dissent in the gun case briefly. It's Thomas and Alito who are dissenting. On our way to the dissent, we have a Sotomayor concurrence. I join the court's opinion in full. I write separately to address 2 points raised in the writings to follow. The first concerns the ATF's rule that might leave regulated entities in doubt and when and how to comply with the Gun Control Act. That worry is unfounded. Kavanaugh writes separately to address mens rea issues with respect to ATF's 2022 rule. Under ATF's rule, an individual or business acting in good faith might nonetheless have substantial difficulty determining when weapon parts kits or unfinished frames or receivers qualify as firearms and thereby become subject to the Gun Control Act's licensing, record-keeping, serialization, and background check requirements. Some weapons, part kits, and unfinished frames or receivers may qualify as firearms, others may not. The line is not entirely clear. Despite the vagueness of the line, the penalties for violations are significant and can include fines and imprisonment. But importantly, under the Gun Control Act, someone can be penalized for violating the licensing requirements if he does so willfully, and he's clarifying the mens rea requirement. Justice Jackson also writes separately. Okay, here's the dissent from Thomas. The government asked this court just last term to rewrite statutory text so that it could regulate semi-automatic weapons as machine guns. We declined to do so. That's the Cargill case. The government now asks us to rewrite statutory text so that it can regulate weapon parts kits. This time, the court obliges. I would not. The statutory terms frame and receiver do not cover the unfinished frames and receivers contained in weapon parts kits, and weapon parts kits themselves do not meet the statutory definition of firearm. That should end the case. The majority instead blesses the government's overreach based on a series of errors regarding both the standard of review and the interpretation of the statute. I respectfully dissent. And then did Alito write separately? Because it doesn't. Thomas's dissent is fairly lengthy and also includes images. Yes, Alito also wrote separately a very brief dissent. The court decides that this is Justice Alito dissenting in the ghost gun kits case. Yes, Tommy, we got 2 decisions. One about the bankruptcy code, where the court clarified a provision that allows you to sue the government, a waiver of sovereign immunity, saying you can't sweep in certain state law claims through that tiny little hole that provides a waiver of sovereign immunity in the bankruptcy code. The second decision, 7-2, allows the ATF to regulate ghost gun part kits, weapon part kits, as firearms, meaning requiring serialization and background check and record keeping and similar things. That was 7-2. I'm reading briefly from the dissents. Alito and Thomas dissented separately from each other. I just read from the Thomas dissent. This is briefly from the Alito dissent that's only 4 pages. The court decides this case on a ground that was not raised or decided below, and that was not the focus of the briefing or argument in this court. Specifically, the court concludes that respondents mounted a facial challenge to the Bureau of Alcohol, Tobacco, and Firearms, the ATF rule implementing provisions of the Gun Control Act, that a party making such a challenge must meet the test that applies when a statute is challenged as facially unconstitutional. That's a very difficult test. That respondents cannot satisfy that demanding test. If I were satisfied that the test should control here, I would join the opinion of the court. The court points to a gun kit that is all but assembled and a frame that is as close to completion as possible. As applied to those extreme situations, the court holds, and I agree, the rule does not deviate from the statute, but I am not certain that that test should govern. So he quibbles with the facial challenge, whether it's a facial challenge, and the broad test that is required. And he footnotes a response to Justice Sotomayor at the very end. Justice Sotomayor's suggestion that I have mischaracterized what this court has held demands a response. Although Justice Sotomayor obviously wishes that the court had gone further, all that the court has actually held is that the ATF rule is not facially invalid because at least some applications of the rule are consistent with the statute. And the 2 examples that the court cites are, 1, a kit that contains all the parts needed to make a semi-automatic pistol, and that can be assembled in 21 minutes, and 2, a frame that can be made functional simply by clipping off 2 plastic tabs and drilling a few holes. The court has not held that any other kits or presently non-functional receivers are covered. A little bit of complicated interpretations there. Okay. I'm looking back at your questions to see if I missed any. Man, doing a TikTok about this case is going to be the silliest thing, because I can't say weapons part kits or gun part kits. Probably I'm gonna have to say pew pew a million times, which is just so weird. I got to come up with another word for it in order to do the TikTok decision. Defending, welcome. We got 2 decisions. One about the bankruptcy code, clarifying the waiver of sovereign immunity that the government allows for a particular claim, saying that you can't sweep in state law claims through that waiver. And 2, in a 7-2 decision, the Supreme Court set hole puncher. A hole puncher might be good, actually. That's a good one. Legos. Legos is good. Oh, arms, maybe. Legos is good. Oh, arms, maybe. No, sometimes it gets flagged and then the TikTok doesn't really make its way around. The second decision is a 7-2 decision from the court allowing the ATF to regulate weapons part kits as they would federally licensed firearms, meaning requiring serialization, background checks, record keeping, and the like. Yes, I am an attorney. Although not practicing. I just do journalism now. Yeah, it's going to be these are some good ideas. Hole puncher might work. Legos. I like Legos. Maybe we'll say Legos. All right. So that was fun. Got some decisions. Is there a spicy talk? I didn't know that. There's a code book? Wow. Sam, quick recap. Yes, we got 2 decisions from the Supreme Court today. One is an 8-1 decision by Justice Jackson clarifying that the provision of the bankruptcy code that allows you to sue the government, 544B, because it's a waiver of sovereign immunity, does not allow you to also sweep in state applicable law claims that would otherwise be barred from sovereign immunity. And 2, in a 7-2 decision delivered by Justice Gorsuch with several concurrences and Alito and Thomas in dissent, the Supreme Court said that ATF, the Bureau of Alcohol, Tobacco, and Firearms, can regulate ghost gun part kits in the way that they regulate federally licensed firearms, meaning requiring the manufacturers and sellers of those kits to do background checks, put serial numbers on the items, record keeping, etc., in part to help law enforcement be able to track down weapons that are used in crimes. You're welcome. And there's a request for a recap. I think I've hit my cap of recaps with the 2 decisions. I will do a TikTok on them later. Maybe I'll do a quick one now and then I'll do a more in-depth one later, so you guys can have it. All right, I think that's what I'll do. All right, happy Wednesday, guys. You're welcome. We'll do this again soon, probably. Have a good day. Thanks, Ian. You too. You're welcome. My pleasure. I will start to be outside the Supreme Court at some point, just not yet. I certainly will if we get some on big argument days. You can also go listen. Thank you, lovely Ginger. You can go listen to the Supreme Court hearing the FCC E-rate case right now. All right, guys, signing off. Until next time, thanks for joining.